Hello, America. I'm Laura Packy, and this is Arizona Today. I'm about to share something with you because following my introduction is a 2-hour legislative hearing that I hope you'll watch. 2 hours. I realize that most people, if it's more than 2 minutes, they go, wait a minute. I understand that. I respect that. The other day, the Arizona legislature did a joint legislative hearing. Members of the Senate, members of the House came together, as you will see. The issue had to deal with parents that were forced into reunification parenting, forced into counseling, forced into some form of forensic evaluation because of the divorce they underwent. And they have children. And so the focus, quote unquote, was on the children. What's in the best interest of the children? So far, that sounds pretty okay. Unfortunately, what has come forward to members of the legislature is something that's not okay. And so there was a 2-hour hearing, and that's what you're about to see down at the legislature. And what's coming is a 7-hour hearing on May 12th. And after that, a couple of additional hearings. It is alleged that monies have been laundered, monies have been squandered, monies have been forced upon parents in the name of reunification of their children during the divorce. Therefore, both parents have to become almost like best buds for the sake of the child. This has been allegedly, purportedly also, alleged and purported by the courts. You will see in this 2-hour hearing a couple of parents that spent $1 million, $500,000, $83,000 to $85,000 with little, if not even harmful, responses. They were not allowed to discontinue. The threat of having their child removed, and in some cases, the child was removed and placed into the other parent's home, even though allegations existed that the other parent, others in quote, the other parent was an alcoholic, a drug addict, a carouser. And yet, the child had no say. The non-custodial parent had no say. And the clock kept ticking, not only on time away from the non-custodial parent, but also on the dollar amounts. Furthermore, what will come out of this 2-hour hearing that you're going to witness, but what's coming up in the 7-hour joint legislative hearing on May 12th is that children have been removed from the home and placed in camps. They were removed from Arizona and taken against their will and against the non-custodial. For instance, you'll hear in this 2-hour legislative hearing how mothers lost their children to the biological father who gave okay to remove the child and be sent to a camp for reconditioning. While the child was at this camp in another state, they were not allowed phone calls, they were not allowed computer access. And when they returned to Arizona, they were not allowed to see, in this case, their mothers, except under supervised conditions. And the supervised conditions were 2 hours once a week or 4 hours once a week, split in 2-hour segments. That visitation had somebody sitting in the room with the mother and the child. So the mother did not even have, or the dad, did not have free access to communicate and bond with that child. I will not continue on and give you story after story. They're horrendous. They're almost unbelievable. What I will share with you is that enough evidence has been already compiled showing that a very deliberate, very well thought out, can I say scheme, has been promoted that has not helped children, has not helped moms and dads, but has cost phenomenal amounts of monies by which a very select group of individuals prospered. Some of these cases have gone on for 5, 7, 10 years. Now, interesting, the testimony you'll hear, when the parent showed up for the mandatory counseling, they had to fill out an affidavit of financial income. Therefore, they had to reveal to the counselors how much monies they had. You will hear people testifying who spent, like I mentioned, $1 million over the years, 500,000. One was 85,000. He cut it off because he went ahead and went and got an additional counselor who brought the whole thing to an end. The stories continue. You're only going to hear 2 hours worth. It has caught the legislature by surprise. It is extremely sobering. It's almost unbelievable. And so an additional hearing is coming, and then one after that. There is also being proposed right now, and Arizona Today will cover it, a forum for the parents. We're working on the dates, the times, and the location of that. But it's coming up rather quickly here because there is a time of the essence issue. And so I wanted to take this moment to tell you and share with you just a tidbit of information of what you're about to see, and it's 2 hours. I fully respect and appreciate 2 hours. You may want to skim through different parts. But the information is extremely sobering. And I say it's the tip of the iceberg, and that sounds theatrical, but I'm going to say it. We were stunned by what little we heard on Monday at the joint legislative hearing. I can share with you that additional evidence, not opinions, has been gathered. I can share with you that there were 39 moms and dads that were victims, and they were going to testify Monday, but there was no time. With the new hearing coming on May 12th, it's been extended to 7 hours. I have every reason to believe, I just got off the phone to one of the people in the parents' network, that there will be twice as many people, 3 times maybe, ready to testify. And while there was about 100 people in the legislative room listening to this hearing, it is not out of proportion to say there will be 2 to 3 times as many in the next legislative hearing. We've also learned in the last 12 to 18 hours that thousands of parents in Arizona and in 2 other states that I cannot name yet have been affected by all of this. Thank you for tuning into Arizona Today. Thank you for allowing me the privilege to bring forward guests and information that otherwise may not see the light of day. Arizona Today did not start 2.5, 3 years ago trying to trap anybody or trick anybody or do gotchas. And you've heard me say that with my guests. I've tried to make it a safe platform so people can share what they have to share, so you and me, or I, can listen to these information and make our own decisions. Ladies and gentlemen, this 2-hour segment that following my introduction here is daunting. It's sobering. And what's coming on May 12th and then right after that is even more sobering. I wanted to share this with you today. I will be back because I will share with you the May 12th hearing. We'll probably break that up into 3 segments. They're 7 hours. So we'll probably do in Arizona Today 2-hour segments. And then the parents forum, where I will have 12 to 15 parents who will go even further into what has happened. And I will have other surprises, surprise guests for you at the parents forum. That's all being worked on right now. So thank you for allowing me to make this somewhat introduction. It may catch you by surprise. It's not a happy introduction. It's not something that you go, wow, I just sit around for the next 2 hours and watch. I wanted to not have you be caught by surprise. I wanted you to hear that what you're about to see and listen to is pretty sobering. I do hope you take the time, and it might take over a couple of days, and I fully appreciate that, respect that. But listen to the hearing and then stay tuned because there's more coming. Thank you so much for your support, for your emails. Thank you for contributing to Arizona Today. I don't go out and have sponsors. That may be something we do. I've never had a sponsor because I didn't want a sponsor to be mad and say, I disagree with what you're saying. And if you don't stop, we're going to pull our ads or pull our support. We, the people, have supported this for 3 years. Some days I've had peanut butter and jelly sandwiches, but it's been worth it. Thank you so much for your support, for your attention. I'm Lyle Rapacki, and that's how I see things from Arizona today.
Joint Legislative Ad Hoc Committee on Family Court Orders is called to order. Will the Secretary please call the roll?
Senator Pinto?
Aye.
She's first.
Representative Carvalho?
Present.
Representative Fink?
Present.
Representative Valdez?
Present.
Representative Warner?
Aye.
From here.
Present.
We have promotions and demotions all at the same time. All right. Ladies and gentlemen, thank you for joining us today. I would like to welcome you to the first of 5 ad hoc committees set up to look into family court orders. After receiving several reports with allegations of abuse and mismanagement, our goal is to collect information from various state agencies and to hear public comment so that we can review the current issues and evaluate potential legislative reforms. Before we begin, please note that everything that is said today will become a matter of public record. We ask that you do not mention any names or share sensitive information regarding active litigation because it's going to be a public record, okay? And I'm sure that any of you that are engaged in litigation probably understand what that means. We will not be accepting any affidavits or legal documents into the record. However, we may accept written testimony if they are properly redacted, meaning the names are taken out. By the end of the 5 committee hearings, we plan to have a report with our findings and any recommendations for next steps. Your input today is very important. And again, thank you for being here. Thank you for sharing what it probably, there's gonna be some tears shed here today. I'm fully aware of that. But we work for you. We're here to make sure that you have a voice, all right? So, next on the calendar, if we could, I'd like to have each member introduce themselves and please give the legislative district you're from. We'll start with Senator Hatatli.
Thank you, Chair. Good morning. I am Senator Hatatli. I represent Legislative District 6, which is northeastern Arizona. Welcome.
My name is Karen Warner, and I'm the state senator for Legislative District 4, which is Scottsdale, Town of Paradise Valley, Arcadia, Biltmore, and Northeast Phoenix.
Hi, everyone. Thank you so much for being here. My name is Representative Rachel Keschel. I'm from Legislative District 17, which is East Tucson, Oro Valley, Marana, and Picture Rocks.
Good morning, everyone. My name is Lisa Fink. I'm with District 27. That includes Glendale, Peoria, and a little bit of Phoenix.
Good morning. Aaron Marquez, representative for District 5, representing Central Phoenix. Thank you.
And I am Senator Fincham, Legislative District 1, which is all of Yavapai County and a tiny bit of Coconino County, just so that we could pull in all of Sedona. Just to give you an idea of what's going to happen here today, the order of events is going to look somewhat like this. We'll have the ombudsman. Who's the ombudsman? There she is. The Citizens Aid, Joanne McDonald, is going to make a presentation about the role of the ombudsman. Just a show of hands, how many of you are aware that we even have an ombudsman? All right, that's sad. About a third of the room. Okay, good. That should be very informative for you. Also, we have the Arizona Board of Behavioral Health Examiners, Toby Zavala. Are you here, Toby? Thank you. And the Board of Psychiatric Examiners, they decided not to be present. Just saying. Then we're going to take public testimony, and then we'll have some closing remarks and next steps for our meeting. The next meeting, by the way, if you want to mark your calendars, will be May 12th. I believe that's a Monday. Zach is telling me yes. So May 12th. It'll be about a month from now. And then we'll adjourn. So with that out of the way, Joanne, if you wouldn't mind coming to the podium and give your name for the record and the agency you represent. Also, by the way, if you haven't, I know we had a couple of people that came in after I made the announcement. If you would like to give any kind of testimony, please fill out one of the white slips that's up here in front, sitting on the countertop, so that we have an accurate count of how many people. It's a time equation. We have to be done by noon. Okay? Ma'am, please proceed.
Okay, thank you. Co-Chairman, Senator Fincham, Representative Keschel, members of the Joint Legislative Committee on Family Court.
Hold on just a second. We're going to have to increase the volume here. Try it again.
Thank you.
That's not even better. Okay. Technology's great until you want it to work. Try it again.
Thank you.
A little better?
Thank you.
Yeah. If you would, just yell into the microphone.
Will do.
Probably be
Will
easier.
do, Senator.
We don't have a 12-year-old to figure out technology up here.
Okay.
All right, please proceed.
Okay, thank you, Senator Fincham and Representative Keschel and members of the Joint Legislative Committee on Family Court Orders. For the record, I'm Joanne McDonald. I'm the Arizona Ombudsman from the Office of the Arizona Ombudsman Citizen Aid, or AZOCA. I was asked to present an overview of our office and how it might help in situations where people have concerns about an administrative act of an agency, board, or commission. They gave me 15 minutes, so you'll pardon me if I kind of whip through this, but I'll stick around, so if people have any questions.
I'll be lenient.
Thank you.
Be lenient on time.
Thank you, sir. So what is the Arizona Ombudsman Citizen Aid? I saw a number of you were not familiar with us. For one, I'd like to point you to pretty much all the state agencies. If you whip out a cell phone, punch in any state agency, we're top center. It's called Citizen Aid on the state websites of every single state agency. But to tell you more about what we are, we're an independent, nonpartisan agency of the Arizona Legislative Branch. We're established to make government more responsive to Arizona citizens. We help people navigate through the government. Arizona citizens can turn to us when they do not know what to do in a government area or when they feel they've been treated unfairly by a state administrator, agency, department, board, or commission. We receive public complaints and may investigate administrative acts of agencies. Services of the Ombudsman are free, and if requested, we treat cases as confidential. The legislature gave AZOCA its authority via Arizona Revised Statutes, sections 41-1371 through 41-1383. And we also operate under the Arizona Administrative Code, Title II, Chapter 16. So, what can the Ombudsman do for me? If a complaint is within our authority, we may investigate it to determine whether one has been treated fairly. If we conclude a complaint is justified, we work with the complainant and the agency to find a fair solution to the complaint. If we can conclude the complaint is unjustified and the agency correct, we explain our reasoning. The ombudsman is not an advocate. We're not someone who automatically takes your side in the conflict. Our job is to consider all sides of a question impartially and objectively and then come to a conclusion. So we don't start out on behalf of any agency or any citizen. We approach it impartially. We discuss the concern with the individuals in confidence. That's by statute. It's a felony if we abuse that in any way. In many cases, we provide information for individuals to solve the problems themselves. We're kind of like the state's librarian, if you will. If people don't know where to go in government, don't know how to navigate, everyone sends them to us and we help them figure out their situation and where to go. In other cases, it is a matter in our jurisdiction and we ask the agency staff to remedy if we see an obvious wrong. In other cases, it's not clear whether it's an obvious wrong or what the situation is. In those situations, we investigate the complaint and negotiate a solution. We cannot order changes in rules, regulations, policies, or procedures. However, most state administrators are cooperative and responsive to our recommendations, and we handle matters informally. We report these in our annual report that comes out every December. If we cannot work out a satisfactory solution, we send a formal report of our findings and recommendations to the state legislature, governor, and the public. An ombudsman has broad powers to investigate and make recommendations, but again, we have no authority to demand or reverse a decision. So what does the ombudsman look at? What is our scope? Upon receiving a complaint, the ombudsman may investigate administrative acts of agencies that I have reason to believe violate one of the following standards. 1, contrary to law. 2, unreasonable or unfair, oppressive, arbitrary, anything in that like area. 3, based on a mistake of some sort. 4, based on improper or irrelevant grounds. 5, unsupported by an adequate statement of reasons. You just got an arbitrary order and no one explained why. 6, performed in an inefficient or discourteous manner. Or 7, otherwise erroneous. There's reasons we may decline a case. As previously noted, under law, the ombudsman will not investigate a complaint until after the complainant has exhausted the reasonable avenues of relief within the agency. The ombudsman may refuse to investigate an administrative act that otherwise qualifies for investigation if, 1, an adequate remedy for the grievance stated in the complaint is already available. For example, the administrative action, if you haven't finished it. 2, the complaint relates to a matter outside the ombudsman's duties. We have no jurisdiction. For example, neighborhood disputes between private citizens. 3, since the topic here is the action of boards, I will note that boards are different from regular state agencies. They're specifically set up in law as topic specialists and are set up as a pool of specially selected individuals. For these reasons, we only look at board administrative acts as it relates to complainants. If a board decides something is normal or not normal in the professional sense, we cannot replace our thoughts for their expert knowledge. For example, we can question whether a board was given the complaint material to consider, but we cannot question if the board decides the complainant licensee acted outside of their professional standards. 4, the complainant does not have a sufficient personal interest. They're a third party. They're the nosy neighbor next door, what have you.
Hey, Joanne, we got about 2 minutes.
Okay. The complainant relates to an administrative act that the complaint has known about for an unreasonable time. Sometimes people come to us and the matter might be 18 years old. So we really get them going way back on this. So if they're untimely, we can't take it. If the complaint is trivia or made in bad faith, or if the office of the ombudsman are insufficient to adequately investigate the matter. Sometimes they put something on the table that is so vast that we'd need a staff of 200 instead of a staff of 12 to handle it. So those are the type of situations where we might have to say, we don't have the resources for that. So when should I go to the ombudsman? The ombudsman should be seen as the final option when other approaches have not worked. If you have a problem, discuss it with the relevant person or office first. They can often explain the policy or fix the issue quickly. Agency staff usually solve issues faster than an outside ombudsman. At this point, it's important to note a few things. First, there are a couple statutes to make you aware of. One is ARS 41-1376, and the other is 1377. And there's an administrative code, too. These all say the complainants may not jump to us prematurely. They must first, quote unquote, exhaust their options within the agency. This serves two purposes. The agency the closest to the matter has the first opportunity to fix it, but B, the dispute has not been handled at the agency, then we pick it up and have a string to pull to follow the trail when we do investigate. Second, the legislature did a wise thing. They set up laws to require every state agency and board to appoint an internal ombudsman within the agency. The internal ombudsman staff are usually set up as people who can get word to agency leadership fast or the directors themselves. They're still on the agency's chain of command, but it gives the public a place to go if their dispute is with line staff decisions.
Okay, Joanne,
Yeah,
are you about done?
just about. I was just going to say, I've got
Let's have a closing comment.
I've got examples and I've got handouts if you wish
Okay.
them. This is on our website. This how to file a complaint that goes over some of the material. So
Okay.
I was right done.
All right, members, any questions for the ombudsman?
Mr. Chair.
Representative Fink.
Okay, first of all, thank you for coming and
Yes.
appreciate your presentation. What can be done to make sure every litigant in family court knows about you and your services?
Well, we try and get the word out about us, and the state has put us in a very prominent place on all the websites. So no matter what the state agency, pretty much we're center on the cell phone when you pull them up. So that's one. Two, all of them are supposed to have their internal ombudsman, and all of them should be referring people to us. So when people say, I'm not satisfied, you've torqued me off, you upset me, you're not listening to me, what have you, that's when they're supposed to say, well, the state set up something just for this purpose. It's the outside ombudsman that's external. They're not part of our organization at all. They're completely external. Take it to them, and they should have all of our contact info to refer people.
Mr. Chair, follow-up?
Please.
My understanding, though, is family court does not have an ombudsman, so do they have to go straight to you?
Family court is not in our jurisdiction. None of the court system is. I'm on a number of court committees because they value our input. For example, I'm on the court improvement committee for the juvenile court system. It's mostly the judges, and if they can get word out. But if people are upset at a state agency, the agencies are within the realm of the ombudsman system. The courts are not. The courts are their own beast.
And to that point, though, from what I've heard you say, you are basically a navigator to help people with the system, even though the court might not be in your jurisdiction. And-
We can help them to a degree. We also point them to the courts. Very plentiful materials. If you looked at the court system about 15 years ago, what was available to the public, it's vastly improved in the past few years. All of the different courts have really put just a huge amount of information about how to deal with them effectively. So if people have not availed themselves of what's online in the court systems, please do. If you're from courts outside of Maricopa County, you might want to look at some of the Maricopa County resources because they just have more people to do more things.
Right,
And
thank you.
it's relevant to all the counties.
Thank you. And to the folks that are in the room, we'll see to it, if you would like to have a copy of this, we'll see to it that we have some before time's up.
Can
Okay?
I ask one more follow-up? Thank you so much. Thank you,
Yes.
Mr. Chair. Is there a reason that the family courts do not have that internal ombudsman? And I'm, as far as I'm aware, DCS does not, and that is an agency as well.
DCS does have a whole internal ombudsman office. There's about 4 people in it. DES and DCS.
So
Okay,
to the
ma'am, please have a seat.
to-
We'll get to you in a minute.
follow up though, what is stopping the family courts from having that? I'm just trying to wonder what the issue
Separate branch
is.
of government, like for example, public record laws cover state agencies, county agencies, cities, special districts, but they do not cover the courts. The court has their own record rule instead of a statute, so they kind of do their own thing.
Gotcha.
Okay. Members, any other questions? Yes, they do. Okay, ladies and gentlemen, this is being recorded. If you have comments, please step outside. I can't have mumbling and grumbling in the background. It's not gonna work for this committee, okay? We're gonna have an orderly committee. People will be called up to give testimony. You'll have your opportunity, all right? All right, ma'am, thank you very much. Next up, we have Toby Zavala, Arizona Board of Behavioral Health Examiners. Tony, please give your name and the organization you represent, and you have about 10 minutes to give your presentation.
Okay.
Thank you. And speak
Good.
right into the mic, because I had to come down about 5,000 feet, and my ears have not equalized yet, so I'm having a hard time hearing you.
Understood. My name is Toby Zavala, and I'm the Executive Director of the Arizona Board of Behavioral Health Examiners. I've been with the board now for 15 years, and I want to thank you for the opportunity to be able to come and share with you what our board does. Our board is what we call a composite board, so we oversee 4 different professions. They would be social workers, counselors, marriage and family therapists, as well as addiction counselors. We currently have over 19,000, and we continue to grow with our licensees. The goal and the mission of the board is to protect the public, and we do that by 2 ways. One way is to ensure the individuals that become licensed by our board meet the educational requirements, which is typically going to be a master's degree as well as a test that they have to pass in order to be licensed by the board. The second piece to protect the public is basically providing an avenue for the public to file a complaint on a licensee that's licensed by our board. Then at that point, our board is responsible to fully investigate that complaint. We currently have 27 FTE. We have 13 in investigations, 8 in credentialing, 3 admin, and 3 in our operations team. 2024, we received 260 complaints. 30% of those complaints received disciplinary action on their licenses based on conduct that occurred that would board considered unprofessional conduct based on clear and convincing evidence. Most of the cases that we see are going to be boundary related. For example, a therapist having a relationship, a friendship, sexual relationship, doing things that are outside their boundaries as a therapist. Maybe borrowing money from a client, clients borrowing money from them, basically acting outside that profession. Again, 260 complaints, 30% received disciplinary action. I didn't have a complete calculation, but just to share with the committee, it appears by my own count as well as the board's enforcement manager, we had between 3 to 5 complaints in 2024 that related to court-mattered items. These matters are looked at in conjunction with being court-appointed, and again, investigated based on whether or not the conduct that the licensee did was clear and convincing to rise to the level of disciplinary action. That's all that I have for my presentation. I'm available if you have any questions for me. I would like to share that we do work with the Ombudsman's Office. Thank goodness we don't get very many complaints that get there, but like I believe all state agencies by law are required to have that on their homepage of their website for the public, so that it's so the public has accessibility of where they can go if they don't feel that their needs or their complaints were being heard or handled correctly.
Well, I can verify that the banner is at the very top of your webpage. So, yeah, it's there. Members, any questions for Ms. Zavala?
Yes, Mr. Chair. Are you affiliated at all with the Psych Evaluation Board? Do you work with them at all?
We are not. They are their own
Okay.
separate board.
Okay, thank you.
Okay. Thank you very much, Tony.
Thank you for having me.
Members, because the Board of Psychologists Examiners is not present, they did send an email with some information. And Zach, if you would, could you please read the germane pieces of that into the record? The email in its entirety will be made part of the record.
Mr. Chair and Madam Chair, members, for the record, Zach Dean, Senate Research Staff for the Judiciary and Elections Committee in the Senate. As far as the germaneness of the email, I think most of it is germane just because I think the presentations so far have mostly just been describing what the agency's roles are and what their staff is and all that. So I'll just be brief. While also mentioning that it's my understanding that the executive director of this psychologist examiners board indicated that they would be available for a future meeting. But in the meantime, I will just read from the email that they provided. They mentioned that they're a small agency with 4.5 FTEs, those consisting of 1 full-time executive director, 1 full-time deputy director who is their main investigator, and I think according to this email the only person who has the authority to do investigations on behalf of the board, 1 full-time project specialist assigned to process license renewal applications and perform administrative functions, and 1.5 licensing specialists, dedicated to processing initial applications for licensure. The second question that was posed to the board was what are the number of complaints that the agency has received within the last 12 months. They outlined that they have received 47 psychologist complaints, including self-reporting of criminal charges, 16 psychologist claims, 19 behavioral analyst complaints, and then an additional 49 complaints that were submitted to the agency, but that appear to lack jurisdiction to open. In these cases, they state that complaints appear to be under the jurisdiction of various other entities such as the Arizona Medical Board, the Arizona Board of Osteopathic Medical Examiners, the Board of Behavioral Health Examiners, or the Arizona Department of Health. The third point just sort of asks for the complaint classifications, which sort of just breaks it down exactly how I just described it. And then the fourth and final question that was posed to them was to provide an overview of each license type that the agency provides, those being the way that they answered this question was that a psychologist is a person licensed to practice psychology in Arizona. The practice of psychology is defined in ARS Section 32-2061 to mean the psychological assessment, diagnosis, treatment, or correction of mental, emotional, behavioral, or psychological abilities, illnesses, or disorders. They go on to note that there are 2,220 psychologists licensed by the board in active status and another 225 that maintain an inactive status with an Arizona license. A behavioral analyst is a person licensed to practice applied behavior analysis in Arizona, which is defined in ARS 32-2013 to mean the design, implementation, and evaluation of systematic environmental modifications by a behavior analyst to produce socially significant improvements in human behavior based on the principles of behavior identified through the experimental analysis of behavior. They go on to note that there are 1,325 behavioral analysts licensed by the board in active status and an additional 31 inactive. And that is where the email ends, Mr. Chair.
Thank you, Zach. Is there any commentary in there about therapeutic interventionist or forensically informed? Are those phrases used in that email?
Mr. Chair and members of the committee, the only place where I see the phrase therapeutic interventionist mentioned is where they're breaking down the number of the claims by category, and I guess it appears to say that complaints against therapeutic interventionists would fall under psychologist claims for allegations against a court-appointed psychologist and who provided court-ordered services, and I do not. And I think you maybe mentioned a second phrase, Mr. Chair, besides therapeutic.
Forensically informed.
Mr. Chair, I do
don't recall
not.
seeing that in the email, but
I don't think
maybe I
that is
missed
mentioned in the email, sir, as far as
Okay.
I've been able to read it so far.
Mr.
Zach,
Chair,
members, any questions for Zach?
yeah, a follow-up. How many complaints does it say that were received for TIs?
Madam Chair, if we're looking at
The therapeutic
therapeutic
intervention.
interventionists would fall under psychologist claims category, which means there were 16, at least according to this email.
Okay, so Matt and Zach, they don't differentiate between non-TIs and TIs?
Mr. Chair, they might. I hesitate to get too far.
In the email that they sent, just in the document itself.
As far as it's a little interesting, Mr. Chair, because, and I don't have the expertise to expound on why this is, but one of the categories is psychologist complaints, and then another category is psychologist claims. I don't know how to differentiate between those two, but there were 47 psychologist complaints, 16 psychologist claims, and then the second or the third point in the email mentions that therapeutic interventionist issues would fall under those 16 psychologist claims,
Okay. All right. Members,
if
any
that
other
is
questions
helpful
for
in
Zach?
any way.
No? Okay. Madam Co-Chair, if you would, could you start calling those individuals that would like to testify? So we have 33 people that
Plus.
want to speak, and we have
And then it's
90 minutes. So just be aware, we're going to set a 5-minute timer for everybody. If you do not have an opportunity to testify today, I ask, please don't be discouraged. Come back on the 12th. You'll have an opportunity then. We're kind of surprised, quite frankly, at the turnout that we've got. Otherwise, it would have made it a 3-hour hearing, but we have a hard stop at noon, okay? So, Madam Co-Chair.
Mr. Chair, I'm not surprised. But yeah, as he said, please know we want all of your voices to be heard. That is very, very important to me. So just know this is the beginning of a process that we foresee playing out over the entire summer, because we want you to have your chance to get on record with what has occurred for you. So I am going to start with Rachel Barnett. And please state your name for the record before you start speaking.
And if you would, get the microphone as close to your mouth as you can. Give us a test.
Hello?
Perfect. All
You
right.
hear me? Okay, thank you. My name is Rachel Cardona Barnett. I want to first thank everyone here. This is the most important of causes. On June 27, 2023, my 4 beautiful boys were forcibly removed from my safe home when a warrant was fraudulently obtained by a documented child abuser with history of violence towards them. In 2019, after 7 years of physical, sexual, financial, and psychological abuse, I made what the Ohio judge assigned to my case referred to as a predatory but very telling deal. To gain my freedom and that of my 5 children, I agreed to permanently waive child support and any obligation our abuser would ever have to provide for the 4 children we share. I further signed over my marital home to him in exchange for him granting me a divorce, giving me full custody of the boys, and a stipulated permission and agreement that I could take the children from our home state of Ohio and start over in Arizona. This, he explained, was the only way he would set us free. It wasn't a hard decision for me. I would choose my children over and over. I would choose my boys over anything. 2 years later, our abuser lost his job and sold the house to avoid losing it. When I refused to return to him, he packed up and came here. The proceeds from the house, or the sale of the house, allowed him to hire a corrupt attorney who would later be forced off the case when I reported her to the bar and produced the recording that proved that she had falsified an assault against my current husband to gain the momentum to have my children removed from my home, placing me on supervised visitation for only 4 hours a month that was monitored access to my children that I had to pay an exorbitant amount of money for. But let's backtrack a little. In 2021, upon the arrival of my ex-husband in Arizona, the court appointed a CAA, which is a court-appointed advisor, to our case. This advisor never met my children. She never came to my home. She made and subsequently canceled 2 appointments to come out thereafter after asking a video chat with 3 young children, twins ages 5 and a 6-year-old. It was very bizarre, but I allowed her to do that. And it would seem she hadn't even reviewed the case history, as she was unaware that there was an active order of protection in place that was upheld by an Arizona judge when my ex-husband said he was coming here to kill me. This was one point delayed. She even delayed submitting her assessment and stated that the reason why is because she had just received a DCS record from Cleveland. There was no DCS record from Cleveland. We had never had any involvement in DCS with our family, so that was a blatant lie. The night before court, this advisor submitted to the court an email to me in which she cited her belief that my children were coached, as they, quote, were too well spoken, a blatantly racially driven observations that she made. She conveyed her belief that I was in the room when she met with my children virtually, 10 minutes total for all 3. My children were then ordered, at her decision, to be dropped off the police station to start week-on, week-off visitation with their abuser, a man that they had witnessed strangle their mother, split open the face of their older brother, and previously admitted to knocking their heads together, a man who was homeless at the issuance of the order, causing my children to sleep in random people's floor on air mattresses in front of sketchy doors and neighborhoods.
You have about a minute and a half, ma'am.
I began researching her, and this is important, and I went to the board, and I do want to say that the Board of Behavioral Health, I do believe they wanted to help me. I filed a complaint. I went and I defended my complaint, and they had no jurisdiction. They said because she was court appointed, there was nothing she could do. They acknowledged that she had done wrong. Her departure put another corrupt family court advisor on my case. This advisor was found to have fraudulently documented several things related to the abuse of my children, hiding things. She was even recorded saying that she knew my children were being abused, but, quote, she had to see her abuser often, so they should have to as well. It was not until a very honest and ethical visitation supervisor was placed on the case in which my name was cleared. But I stand to you today and stand in front of you still trying to fight for my children. Since June 27, 2023, I still do not have custody of my children. And the reason being is I'm fighting the reports of two very dishonest, very unethical people who continue to cover it up so that they can continue this money train. And my children are denied services and support that they are deemed necessary because such would cause and expose everybody. So please, I want to say this in closing. I ask of you who are in this prominent position of power, please do something.
All right, thank you very much. Members, any questions?
Mr. Chair?
Representative Fink?
You said it was an advisor that made these recommendations. Was that, and you said that the behavioral health couldn't, the board couldn't do anything. So who was that advisor? Was it a psychologist? Was it what was it?
Thank you so much for asking. In fact, when I did research, I found out she just had an associate's degree, and she was a drug and alcohol treatment counselor. She had no experience, no education related to family court, or even working with children at all. But because she was court appointed, it wiped out the necessity for her to be licensed in an appropriate manner. So it didn't matter.
Mr. Chair?
So do you feel like you were coerced into this situation?
Well, I was absolutely coerced, absolutely.
Okay. Well, Representative Fink, I'm sorry, did you have another question?
Mr. Chair, Rachel, my question is also is that because it's court appointed, I guess it'd be more of a question even for the Behavioral Health Board, that they had no jurisdiction. So who does have jurisdiction?
No one has jurisdiction. In fact, I do want to say this, and I was very grateful when she came up and spoke. I do believe they wanted to help. There was a panel, I want to say, of 10, and even they went to the back because they were so shocked by my case, the pictures and documentation that I presented, and they wanted to do something. They went to the back and convened for about 15 minutes, came back out, and even with their hands being tied, 4 of them said, I will not vote to clear this woman. And so it was dismissed because it was 6 who were, they had their hands tied and they had to. But when there's court appointment, it's almost like they're handed a God complex. Get out of jail free. No one monitors them.
That's a problem.
Okay, ma'am, and I noticed that you were reading from a document. Do you want to submit that to the committee for the record?
Yes, sir, please.
All right.
Mr. Chair, really quick,
Yes.
Rachel. So you just said, and I was going to touch on it, you had documented proof of abuse. What was it that you showed the court, and then what was done with that?
So there were photos. In my case, there were no less than 10 mandated reporters who reported the abuse of my children. My children had been waterboarded, they had been strangled, and there was medical documentation from Phoenix Children's Hospital that showed trauma to one of my children's testicles. And the child expressed how it happened. My children are very articulate, but there's no reason for them not to be.
Okay, let me get this straight.
Yes, sir.
The allegation is that happened while the child was in the custody of the father, not in your custody. Is that correct?
Absolutely, yes, sir.
All right. Members, any other questions? All right, thank you very much, ma'am.
Thank you. Who would I submit this to?
Zach will take it from you.
Thank you so much.
Next up.
Okay. Mr. Chair, next up is Robert Del Garbino.
Mr. Del Garbino, if you would please give your name and who you represent, if you represent yourself or an agency or an organization.
Good morning, Senate Committee Chair.
If you would please get as close to the microphone as you can.
Good morning, Senate Committee Chair and the esteemed members of the committee. My name is Robert Del Garbino. I represent myself and thousands of families in Arizona. I've lived in Arizona since 1980. I'm fairly well educated with a bachelor's in engineering and a master's in business. My family was torn apart and financially burdened by bad actors in the family court system. These were comprised of psychologists and therapeutic interventionists, with or without the collusion of judges, I do not know that. But they, the bad actors, the psychologists and therapists, orders were followed by the judges. Whenever we would go to court, the judge would turn to the therapeutic interventionist or the assigned psychologist and ask, what do you think? What do you suggest? When the orders would come out, those orders were followed. My son has reached the age of majority and is no longer in danger of further psychological brainwashing or additional parental abuse. I speak today, again, not only for myself, but for many families in the state of Arizona. Now, I would like to temper my statement just made by saying that there are some good providers within the system. At one point in my case, I got the bad actors to be recused from the case. I got a very good psychologist that reunited the family after 2 years of being apart, back together in 3 weeks. So the prolonged fees and cost of doing that were shortened a lot. There seems to be a lot of money to be made in our system as a psychologist by prolonging a family problem. Many people here today still have children 10 years and younger that are trapped in a system. And the psychologists are benefiting from it, the bad actors. My ex-wife and I spent over $80,000 in 3 years to psychologists and therapists. And it only took one in 3 weeks for $2,000 to solve the problems. This is a typical example of how the bad actors operate and abuse the family court systems. First, let's understand some of the terminology. TI stands for therapeutic interventionist, and then sometimes there's a COBE or a psychologist assigned. They need to be forensically informed and certified in order to provide the information to the court system. So you can't just grab a psychologist and go with them. That is a difference. I'm not an expert on that fact. I'll let others speak to that. Okay. Once they're assigned to a case by the judge, the TI gets themselves assigned, typically to custody battles with parents of some means. And the way they do that is whenever you go into a custody battle in the state of Arizona, you provide an AFI, an affidavit of financial information. This tells everyone how much money you make and how much could be garnered by bad actors in the system. The TI may be referred by a judge through making themselves aware of their practice, sometimes simply through the circle of influence, i.e., illustrated example, other counselors, therapeutic interventionists, psychologists, and unfortunately knowledgeable abusive parents who have found how to use this system and scam it using the internet as their guide. Out on the internet, there's information on how to win in family court by leveraging this paradigm set up by the psychologist. That paradigm pits an abusive parent against a well-meaning parent,
Got
a
about
protective
a minute, Robert.
parent. Say,
You have about a minute.
right, I'm about to wrap it up. This paradigm's important because the psychologist will shift no contact orders onto the protective parent, forcing the child to live with the abusive parent. And of course, the protective parent will spend whatever it takes to save that child from the abuse, further abuse by that parent. This paradigm continues. The psychologist continues to pocket more than $1,200 a week. Typically, they charge $300 to $500 an hour. The father has to see the psychologist, the mother, And the children, 1, 2, 3, 5 children, that adds up, more than $1,200 a week.
Time.
Time.
Robert, thank you very much. I wish you had more time, but
We have 4 more hearings.
Yeah, that's
we
right.
do.
So,
Thank you for reminding me.
Mr.
Any
Chair,
questions?
I do have a question. So you said that there are some good providers.
Yes.
So my first question, if you had to put a number on it, is it a handful of those that are,
Less
scamming
than
the
a handful
system?
to my knowledge.
Okay, and you said that you were able to get your TI to recuse him or herself. How did you go about doing that?
I presented evidence that questioned the individual's moral integrity, trying to find the proper words without getting in a liability case.
Turpitude.
Thank you. Yes. Overwhelming amount of evidence, actually.
Good.
Just,
Representative
Mr. Chair, real quick follow-up. Was that through the psych board that didn't bother to show up today, or how did you present that evidence?
I garnished it from many of the parents that are here in this room, and some that, cases that had gone to court previously, doing some court research with that particular person's name in that. So I was able to bring this all to the court, put it forth in the court, expose it, shine the light on it. And this got the TI to recuse himself. He backed away, ran and hid like a cockroach that he was.
Mr. Chair?
Ms. Fink.
Sorry. It's a little emotional.
I'm going to give you a latitude. I
Thank you, sir.
understand how emotional this is. Thank you for not using a name. Representative Fink.
My question, Representative Keschel asked one of my questions, but I have another one. Because you mentioned that you were in the hearing and that you saw the judge turn to the therapeutic interventionist and ask questions. Currently, there is statute 25-403 that goes through legal decision-making in regards to determining the child's best interest and parenting time. Did you see, I'm not going to go through all of these lists, did you see that happen at all, going through?
No, the child, he was 17 years old over the course of this. He had begged to speak to the court. The judge wouldn't hear him, wouldn't speak to him. We're talking an intelligent young man, high IQ, studying genetics now in college, national recognized marksman, champion, a solid individual. And the judge would never speak to the child. And to answer your question, this didn't happen once. This 90-day extended no contact went on for over a year, or almost a year, and every time the judge would turn to the TI and say, what do you recommend? He ran the show.
To that point, Robert, could you share what was the justification for no contact?
There was none, sir. There was no justification whatsoever, with the exception, my ex-wife's attorney stood up in court and said, he alienated my child. He alienated, he's a parental alienator. No proof, none whatsoever. That's all it took, was that word from the lawyer's mouth.
So it would seem that the reaction was to alienate the other parent?
That was the claim. There was no evidence.
Hear me.
Yeah.
So the claim was that you were alienating your ex-spouse.
Correct.
So the solution was to alienate you for
Correct.
90-day periods. That's the crux of my question.
Yes,
Okay.
Yes.
Right.
Exactly.
A follow-up question. You said that 80K, and you mentioned that under a TI it went on and on and on. Yet under a new TI, it was 3 weeks and the issue was resolved. How much time was it, time and expense, if you know both figures, was it at the front end?
At the front end, approximately $75,000, and over the course of 2 years. So,
$75,000 over the course of 2 years.
yes.
With periods of 90 days
consecutive periods of 90 days of no contact. I didn't see my son for 11 months until he was nearly 18.
Okay. Then the 3 weeks, that time period, we understand.
Yes.
What was the relative cost for that?
About $2,400 or less.
$2,400?
Correct. The
of
problem
the
was solved by the
$80,000.
knowledgeable, yes,
So that's part of the $80,000
Yes, sir.
total?
roughly.
Okay.
Mr. Chair?
Ms. Fink?
I've got some exact numbers here if you need the
No,
exact
that's,
numbers,
ballpark is
but-
fine.
Yeah.
It makes the point. Yes, ma'am.
My question is this, okay, so the judge said parent alienation was the reason. Do you know what statute that she utilized that?
None.
Okay.
It was the simple verbiage. The lawyer stood up in court and said, he alienated his child from his mother. No evidence, no proof, and factually, it did not happen.
Robert, did you, and if you don't want to answer this, don't feel compelled to. Did you participate in any one-on-one, for lack of a better term, counseling sessions with you and your son with this therapeutic interventionist?
I'm sorry, did I?
Did you participate? Were you a part of any sessions with your son with the TI?
Not with the first TI. The 90-day no contact TI would not even allow me to attend the intensive family therapy that was ordered by the court to happen. So it wasn't family therapy, it was the son and the mother. I was excluded for no reason.
Okay. Members, any other questions?
I have one more. So when you were, I mean, it sounds like $75,000, that's a lot of money. So I'm assuming the hourly rate for this TI was astronomical, from what I've understood. Did you have any choice in the matter to have, you were basically just forced to use this particular TI, is what I'm gathering, at a certain set dollar
Directed
rate
by
and
the
had no
judge.
option?
Yes, directed by the judge.
One at a time.
Sorry.
Let her finish her question.
That's basically it, Mr. Chair. I'm just trying to clarify what I was gathering.
The judge ordered who we would see, who the family would see. It was the judge's decision.
Okay.
Now,
right,
to
members,
temper that, the second round, when the first TI was recused, it was a blind choice. Mother and father each provided two providers. And there was a blind choice.
All right.
I got lucky.
Members,
Many
any other
parents
questions?
behind me are still in this situation. Remember, this is not just my situation. There's so many parents in this room that have the
Understood.
same situation.
Understood. All right, members, any other questions? Great, thank you. Robert, thank you very much.
Thank you.
And if you have, do you have a document that you wanted to submit to the committee?
I can email that to your office if that's
Okay,
acceptable.
yeah, if you would, thank you
I
very
will,
much.
sir.
All right, next up.
Sophia C.
Ladies and gentlemen, as you can tell, we're trying to move expeditiously through this to try and get as many people as possible an opportunity.
Good morning, Chair Fitchum.
Okay, if you would, get really close to the microphone.
Okay.
Okay? And then your name?
My name is Sophia.
What's your last name, Sophia?
Clever.
Okay.
Good morning, Chair Fitchum, Chair Cashel, and committee members. My name is Sophia, and I'm 15 years old. I'm a high school honor student. Me, my 10-year-old sister, and my mom have been victims of family court for over 5 years with no end in sight. Our case first started when the court appointed a Kobe for over a year and a half. The Kobe met with me and my little sister 2 brief times. She never listened to our concerns, and we felt ignored. In her final report to the court, she stated that reunification therapy was needed. This was confusing because me and my little sister attended every parenting visit and overnight. We did everything she asked. Additionally, the Kobe encouraged our father to have a supervisor for 4 months. However, the supervisor only had a high school education. She was placed in a therapeutic role by the Kobe and the court. The supervisor charged my parents over $25,000 in 4 months. After this, the child therapist was ordered, but she took it upon herself to act in a TI role, even though that wasn't what was ordered. She violated me and my sister's confidentiality when she reported to the court. Whenever I would disclose present and past abuse, she would tell me that the present and past didn't matter. Despite me repeatedly telling her about abuse, she kept ignoring my cries for help. The child therapist would bring my father into me and my sister's sessions. Together they would berate us, bully us, and make us cry. Because of her, I don't trust any court-appointed therapist. Therapists are supposed to help you, not hurt you even further. Is this really in the child's best interest? Then, with no evidence, the child therapist reported to the court that me and my sister were enmeshed with our mother. This was confused because me and my sister were attending all scheduled parenting time and overnights. We did everything she asked. She and the PC also stated to the court that my mother was an alienator. The child therapist has a certificate in play therapy, but was making these recommendations to the court. The child therapist also had a meeting with our court-appointed parenting coordinator and another doctor recommending reunification therapy or reunification camp. It started with them trying to send us to Turning Points in Texas. Ultimately, it was court-ordered that we would go to an in-state reunification camp/program that would take custody away from our mother immediately. Our parenting coordinator was appointed for over a year. She is only an attorney with no clinical experience. Me and my sister never met her. She was making clinical decisions for our family despite only being an attorney and never talking to me or my sister. A case manager was ordered as a clinical manager with our family, and he appointed himself and another therapist to the court. This case manager in the court tried to get my mother to sign a 50-page consent, making her agree to take custody away immediately. My mother spent over $550,000 to date and lost all of her life savings and investments. My mother was also court-ordered by the judge a year ago to sign a HELOC on our home to pay for the newly appointed custody evaluator. Can family court force a parent to take out a second mortgage on their home? Isn't that a violation of constitutional rights? They can't force them to sign financial documents. Ultimately, the judge reversed custody based on no evidence or on court findings. This was based on hearsay of my father's attorney. This decision was made with no due process. The judge gave my father full legal custody and full legal decision-making. The judge stripped my mother of all of her parental rights. She was told that she could only see us 2 to 4 hours a week with supervised parenting time. All of this was not in me and my sister's best interest. For over 3 months, we lived in fear. We were depressed and terrified. We lost many friends and missed doctor's appointments. We missed many dance classes and had food taken away regularly as punishment. Despite how much money my parents were forced to pay these court appointees, the court appointees did not act in me and my sister's best interests. The court is always talking about best interests for the child, but how is this in my best interest? The only people who gain anything from this are the court appointees who make tens of thousands of dollars stripping parents of their savings, investments, and homes. These court appointees create constant conflict to keep the money flowing. Thank you for giving me a voice. I politely urge you to please take action and help protect children like me from these TIs, COBIs, parenting coordinators, therapists, and judges. Thank you for your time, and with that, I'm open to any questions.
Mr. Chair.
Sophia, thank you for your courage. Representative, thank you.
My question, because I helped out with parents in getting the reunification camp ban bill. And did this happen before or after the ban, the reunification camp?
Custody was taken away about 10 days before the ban came into effect.
Mr. Chair,
Yeah.
Sophia, thank you for sharing your story. Now, you mentioned abuse. I don't want you to go into that. Just to clarify, your dad still has full custody of you at this
No.
point? Or you're good now. But was the abuse, because you mentioned someone told you, oh, it's in the past, it doesn't matter. Did that continue when you were only seeing your mom for 4 hours a week?
Yeah, the abuse did continue, like when we were still a supervised parenting time. And when we were with the child therapist, she told us that even if the abuse happened yesterday, yesterday was in the past, and that yesterday doesn't matter.
Okay, Sophia, you said, I want to make sure that I've got the number right. $550,000, not $55,000. $550,000 went to a court order for psychologists, therapeutic interventionists, whatever.
Yes.
And what, over what period of time was that, Sophia? Was that a year, 2 years, 5 years?
It's to date, so about 5 years.
About 5 years. Okay,
Yes.
so roughly $110,000 a year. Okay, the next thing I'd like to know is how often did you meet with this individual that was billing your parents for this?
We met with the child therapist about once a week.
Once a week
Yes.
for 5 years. Okay, members, any further questions?
Mr. Chair.
Senator Warner.
Sophia, just thank you for coming forward and being courageous and standing up for yourself. I'm very proud of you and keep fighting.
Thank you.
You're a courageous young lady.
Thank you.
Next.
Do we have Angie Nielsen? Okay, come on up, Angie.
If you would, please give your name for the record, and if you represent somebody other than yourself,
Okay.
would you please do it? And please get as close to the microphone as you can. Part of the reason is so I can hear, but because this is being recorded and it's going out live stream all over the place, folks are telling us, hey, we can barely hear what people are saying. So if you would get really close to the microphone, and
Okay.
now your time starts.
Okay. My name is Angela Nielsen. I go by Angie to friends and family. Thank you, Senator Fincham and House Rep Fink and Ketchel for calling these meetings together. I'm going to be careful what I say today. I was prepared to say names. I won't. But I'm here today to speak for my son, now 16 years old. We've been embroiled in the family court system for 14 years. I have spent right at $1 million. I have spent my $350,000 that I had in my retirement. I'm down to $6 in that account. I have spent my parents' money. I now work 3 jobs. I work a full-time job, work a part-time job, and another part-time job. And I have had, there's a group that come into every case, and yes, they look at the AFI's, Affidavit of Financial Information, and they must come in, oh, this is a rich one, this is a rich one, this is not. My ex-husband has more wealth than me by far, and I believe that he uses the court system to continue this. I just got a threat by him and his attorney on Thursday, the 10th of April, that I only get 4 hours of supervised parenting time right now, and I pay her $125 an hour. I pay $2,000 a month to see my 16-year-old son, only 4 measly hours a week. And they said she needs to be forensically informed. She has said there's no reason for me to have a supervisor. She's never had to use therapy on me. I have passed 4 psych evaluations. Every time I try to get the father to take one, somehow I end up being forced to take one. No findings, 100% pass. And I have had my expert testify to the judge and tell her there's no findings. If anything, I'm traumatized by the family court system, as are my children. My daughter, Victoria Nielsen, spoke at the Senate last year and helped to get SB 1372 passed. She also is a very courageous young lady. She is also an honor student at Oregon State University, has made straight A's every single term, not a B ever, all through high school as well. My son is also an honor student and very well spoken. They have been interviewed. They have said that they want to be with their mother primarily, and it is ignored by the judge. There are certain judges, I believe, in this system that are the ones that take children from families with no valid reason. My daughter was on the front page of the Wall Street Journal in August of this last year, trying to explain that she wants her brother to come home as he wishes as well in every card and everything he writes to me, his mother, the preferred parent. I've always been the preferred parent. And now I'm being threatened once again to go to court to have a trial, and I don't really know why. I only get 4 hours a week anyways, and I'm supervised. And when you say supervised, this is in the therapist's office. You sit on a couch and you're allowed to parent your child for 2 hours at a time while being watched, and every word you say is typed. If you can imagine someone sitting there typing your every word. I've been doing this since November 27th of 2023. It first was offered to me December of 2022, and I kept putting in somebody that I could afford, and they force you to, and once again, same thing as Robert said, they force you to have who they want, and Sophia said it as well, who they want you to have. And so I'm just asking you to please help me get my son. My son has been gone and was forced to a reunification camp called Building Family Bridges, May 20, and Victoria as well, both of them. Marcus was 12 and Tori was 16. And we outlawed Building Family Bridges and all reunification camps last year, but yet I am still doing their aftercare. That's what I'm doing right now. And one of our rules in our SB 1372 was number 1, a no contact order with the aligned parent, me, the preferred parent, can no longer be done. My son doesn't get to call me or talk to me anytime except outside supervised parenting.
Your time has expired, Angie. I have a question for you. You called it a reunification camp?
That's what they call these camps, and that's what we outlawed
Okay, so
with SB 1372.
this is kind of a mind blower to me.
Okay.
So you separate a child from a parent, and they call it reunification.
Exactly. And I had my kids full-time for 2 years. Before that, we had 50-50 because DCS gave my children to me full-time. And I had a point. Full-time for 2 years, and that was overturned because my ex-husband has his regular family law attorney, and then he also hired an additional attorney. And these 2 law firms are famous in this area for taking the kids from their preferred good parent, never done any harm, and putting them with the other parent.
Okay. On your slip, please make sure that we have your contact information because I want to follow up with you. All right?
Okay.
I want a little bit of clarification, if you don't mind. You said $1 million that you spent?
Yeah.
That's just you?
Yeah, that's me and my family.
And, well, no. Well, okay.
Well, pretty soon you have to start getting help.
So you're pulling
And I
resources
bankrupted
from
twice.
outside of your household, but within your family, like mom, dad, grandparents?
Yeah, it ruins the entire extended family, as well as the children and yourself.
Okay. And this has happened over what period of time?
Since 2011, so 14 years, they have kept me embroiled for basically no reason.
And the total bill is $1 million over 14 years?
Yes.
All right. Members, any questions?
And like my daughter always says, Mom, you're harmless.
Representative Keschel.
Yeah, Mr. Chair, Angie, the reunification camps, and I've specifically heard of the one you mentioned. To your knowledge, after SB 1372 passed, because that outlawed those, are they still, is that still happening? Is it happening specifically with you? I know that you parents network pretty well. What have you heard about those since?
Well, I would say yes. I think that opposing counsel and father are still being guided by Randy Rand or his cohorts as to what to do to keep me away from my son and to keep the money. I've spent $34,000 with my supervisor. Okay? So that's a huge amount of money to anybody. $2,000 a month is a mortgage.
Just so you can have access to your child?
Yes. It's
for
like
4 hours?
For 4 hours per week, 2 hours at a time.
And of course, you're billed for every second of it.
I have to pay right then and there. If I don't pay the $250 that day, I don't see my son.
So the ongoing nature of this, forgive me, but it just reminds me of a statement, the goose that laid the golden egg. It sure seems like that.
Kids are the golden egg.
Was there any opportunity to exit? Is there an exit ramp? Is there a plan to be done? Was there any kind of a treatment plan? Treatment, I'll use that term loosely, that you were presented with? Here's the goal, here's the objective. Were you ever given that, or is this just an ongoing thing?
I keep trying to have settlement agreements with Father, but he keeps kicking the can down the road and not allowing it. We were just doing that now. I got 4 psychologists that I've been talking to, and one was working with us specifically and talking to him, and then all of a sudden he just decides, no, I'm not gonna. In fact, let's just have a trial. Well, my attorney right off the bat says I want $10,000. So it's huge amounts of money that they're asking for all the time. But I have tried several settlements agreements. In fact, that's how a settlement agreement is how I got in this position, because it's one of the court appointees that just railroaded us right into, she would just bring on more and more people, and then they surround you. They say you're an alienator. I actually tested on one of my tests that I don't have an alienating personality. I would blame myself before I'd blame somebody else.
Are you aware of Arizona Revised Statute 25-418? Most of the parents in this room probably ought to know that one.
Okay, let me write it down, please.
25-418.5. You cannot be coerced into an agreement. That's a violation of state statute. Members, any other questions?
Mr. Chair?
Ms. Fink? Please, quiet.
I think you already kind of alluded to it. You were 50-50, and then you had full custody. What was, according to statute, what did you violate to lose custody of your children?
So I had 50-50, and then a court appointee that Father had gotten and paid for turned what the children were telling her into DCS. They acted for once well and did a good job, and then gave me full custody. And then like I said, I tried to do a settlement agreement, and then this therapeutic interventionist came on the case, and then she got all of her friends, the same that are on most of these cases, to surround me and say I'm an alienator.
So alienation was the,
Yeah.
was, quote, the reason for you lost custody.
Yeah, and it's my kids telling what happened to them. They're living it. And the court appointees are the one turning it into DCS, not me. But opposing counsel constantly says it's me. There's no record of me calling DCS. You won't find it.
Okay, just a point of clarification, and by the way, we're not going to try and litigate this here, okay?
Sure.
You said all their friends. Who, I need some clarification there. Who all there?
Well,
who are you referring to when you say all their friends?
So there's a certain group of psychologists and master's degreed TIs that work together to gang up on a parent.
So would you characterize
for
that
money.
as a closed community? Please, I cannot have people with outbursts. If it happens again, I'm going to have to clear the room. Would you say would you characterize that as a closed community?
I think so.
Okay. Members, any other questions?
And I have a transcript, sir, that one of the members admitted to me that he meets with certain names, and he said the names. It's on the transcript, and he was recorded. He allowed me to record him, of who these close community members are.
Okay. Angie, do you have the transcript?
Mm-hmm.
If you would like to submit that to my office, of course, we'd like to have you redact the names of the patients.
Okay.
Patients, the children. Okay. You don't have to do that today, obviously, but if you would, I'll have you get with one of our staff, and I'd like to get that document. Okay.
Yes.
All right.
And I just want to say, I'm fearful to be up here today because my son is still not with me. And I only see him 4 hours.
How old is he?
16. He just turned 16 March 7th. But I think he's afraid.
Might look into emancipation of the minor.
Okay.
Talk to the ombudsman about that.
With all due
She's still here.
respect, they
All right.
don't help.
All right. Thank you very much.
Okay.
All right, next.
All right, Dominic. Mr. Chair, I call Dominic. I'm not going to butcher your last name, Dominic. I'll let you say it at the podium.
So we have 45 minutes left, and as you can see, this is a very tedious, time-consuming process to give members on the panel an opportunity to ask questions. I promise you we're going to get through as many people as we can by noon, all right? Dominic, if you would, please give your name and who you represent, if you represent an organization.
Good morning. My name is Dominic Scapitici. I represent myself. Let me just get this pulled up here. I'm a father in the family court system. I've had my son Oliver since his birth every week, half the week, for just shy of 2 years. After 45 minutes in court, I now have him 8 hours a month. I pay $2,000 an hour in legal fees, testing fees, and supervision fees to see my child. I'm sober, yet on 4 forms of drug testing. These orders are conflicting. I can't get any rulings in my favor, nor can I get any rulings on evidence that is ephemeral or likely to disappear. The rulings are even timed to prejudice me. My judge, before I walked in that room, had her mind made up and orders written, even though opposing party didn't get their information in until only hours before. My judge has said before in front of my attorneys that no matter what people say, she prides herself on knowing what is really happening based on her own assessment. For me, that causes fear. I apologize, I'm a little under the weather. I've been effectively, for all intents and purposes, removed from my son's life. By the time I possibly have him again, meaningfully, I'll have missed out on 25% of his lived life, major milestones, and during the most intensely developmental time of his life. I'm currently getting the parenting time of a prisoner. I'm a business owner. I am sober. I'm not a criminal. Every motion takes 60 days for me to get relief or does not get any ruling, but on opposition's end, it's instant. How can we do this to our children? How can we take a parent out of a child's life like this? 3 times of seeing my son, he's left screaming, "Daddy, please no." And this is the best we have to offer. Why should justice vary so wildly? I've been told depending on the judge, results may vary. Why can I not go from one judge to another and get the same ruling? Statutes were written to be followed. I should have 50% of the time with him based on the law, and I don't. How is this justice? How is taking a father out of a child's life the best option? And my attorney has told me that judges routinely do not order attorney's fees, which allows the person with more money to buy the best justice. The statute says, shall award attorney's fees, but the judges do what they may. I'm being financially crucified and extortion for my child. It's currently costing me over $4,000 an hour to see my son for the 8 hours a month I get him. How should money be the deciding factor of who gets what? This is not justice. This is pay to play until we are all broke. It is mutually assured destruction. When the families are broke, is this in the best interest of the child? How's family court outside of the law? How can a judge allow any parent to be so financially destroyed just to see their child? None of this serves the child. They're weaponized. We are better than this. We should be better, for our children's sake. Please find me after this so that we may band together and take action on this. People I know are taking action in the next election because this is how our voices are heard, and I hope that anyone here will be a part of it. For me, this is no different than child trafficking. People are making money off of this in extreme amounts, and the only difference is we have it under the guise of being legal. That is all.
Thank you, sir. Members, any questions?
Mr. Chair.
Representative Fink?
Dominic, thank you for coming.
Of course.
Question in regards to this. How did you lose your custody? In other words, was it a TI came in and said that you weren't qualified? What was the reasoning? Again, was statutorily, why did you lose custody?
There were allegations on both sides. Photos of things that, in conspiracy against me. I've been in the service industry for 20 years. I have alcohol in my home. I was made out to be an alcoholic. She had a photo of her hand with a bag of uncontrolled substance. It was muscle relaxers, pills. So I was made out to be a drug addict. I have done 2 hair tests that prove that I'm dead negative for everything. I went to AverHealth, and 2 gentlemen that were doing my hair at AverHealth said that's not his hair, as they were pulling hair out of my hair. Then I show up for cocaine. Immediately after this, I do another hair test, dead negative for everything. I could not get the judge to order another hair test until we recently had our hearing. I did another one. I'm sure this will be dead negative as well. And I've done drug testing. I'm on breathalyzers. I'm on mouth swabs, and all to see my son for stuff that was fictitious allegations. After you prove yourself to be innocent with drug testing, it should just be immediately awarded that you get your child back. This is a person that I spent a year and a half trying to make it work with. It didn't work, and so she's weaponized my child against me, or so it feels. This is not in his best interest. It's one thing to hate me, but we shouldn't hurt our children over this.
Thank you.
Members, any other questions? Thank you, sir.
Thank you.
Again, thank you for your courage in coming up.
Absolutely. Thank you, guys.
Next.
Next, I would like Michelle Fox to come to the podium.
Michelle Fox? Oh, I didn't see you behind the post. All right, please give your name and who you represent, unless you're just yourself. You have 5 minutes.
Thank you. My name is Dr. Michelle Fox. I'm here representing myself. Thank you so much for having me, having all of us here today. My family court involvement lasted 8 years, and I'm days away from, God willing, it being finalized completely. I have 1 son. I lost custody of my son for a total of, well, it's still days away. It'll be 6 years. For 4 years of that time, I was placed on supervised visits, at one point totaling $4,000 a month in fees to again be extorted to see my own child. The reason for that was during shared custody, my son was showing physical signs of abuse, severe sexual abuse, which was confirmed during 2 forensic interviews with law enforcement and DCS. When this was presented to family court, all evidence was denied, and in fact, during a temporary orders hearing, a counter allegation, which was completely fabricated, was made that I had left my child unattended in a hot vehicle. This allegation arose from a best interest attorney who was appointed to our case, a notorious individual who's been on several of the cases, and the parents behind me as well. And as I tried to defend myself on the stand, this best interest attorney violently threw a stack of papers that hit me in the face, and the judge did nothing. I was stripped of my parental rights and ability to see my child at the tender age of 4 years old, and went 90 days with having no contact with my little boy at all, despite court orders. A TI was appointed to my case unlawfully in violation of state statute, which requires an active and open custody or divorce proceeding to allow the appointment of these individuals. That I was ultimately awarded equal parenting time, though not custody, with a caveat that the TI would be responsible for dictating the specific reunification schedule and return of my parenting time. This TI proceeded to recommend a specific family court visit supervisor who's also been responsible for the harm to countless families. And the 2 of them worked in concert very well to suppress the outcries of my little boy, who was in severe distress, severe harm. It was very clear what was happening to him, and all was maliciously covered up for profit. I took my evidence, clear, convincing evidence, back to court time and time again. And time again, the judges refused to see what was happening. It wasn't until a year ago, when the judges rotated out and I was finally placed in front of a new judge, that he upheld my constitutional right to parent my child, and ruled that the placement of the TI, in my case, was unconstitutional. They are not endowed with the authority to restrict parenting time. They should not be placed on cases that are over. And fortunately for me, that judge recognized that and restored my rights. The damage that's been done to me, and more importantly to my child, can never be repaired. I spent over 8 years of my life. My child spent over half his life. $300,000 in fees. What's happening defies belief. What's happening
You have a minute, ma'am.
is so atrocious and so horrendous that I feel that most people simply dismiss it off the cuff, because it doesn't seem like this sort of evil could actually happen, not to people like us. But it does, it is, and I just urge you all to keep listening, and hear our voices, because our children desperately need your help. Thank you.
Thank you very much for your testimony. I just want a point of clarification. So you did not have an open custody argument in front of the court, correct?
At the time that I had 2 TIs, but this particular TI was appointed. Actually, both of them were appointed. No, my case was closed. And
But
final.
the judge, even though there was no foundation, even though there was no statutory, so statutes do one of 2 things. They either permit or prohibit,
Right,
okay? There's no in between.
right.
So what I think I hear you saying is there was no legal authorization for the court to make that appointment, yet the court made that appointment anyhow.
Yes, sir, that is correct.
All right, members, any other questions? All right, ma'am, thank you very much.
Thank you.
Next.
Okay, Mr. Chair, I don't want to be accused of hearing one side of the story here, but I do ask that the audience respect what the chairman has already set forth when I call our next speaker up. I know there's high emotions and, strong feelings, but we do have a TI here. I assume I've heard her name before. Kristen Alcott. Is she here still? Okay. Thank you.
Ms. Alcott, if you would give your name and who you represent.
My name is Kristen Alcott. Chair, members of the committee, thank you for the opportunity to speak. I am both a parent and a professional working within Arizona court systems, but I am not here as a professional. I want to begin by acknowledging that the concerns raised about TI work are real. I think everyone working within the family court system can agree that issues like cost, role clarity, and the emotional toll on families deserve thoughtful discussion. But I also believe it's important to offer perspective about what is often at the root of those concerns. In my experience, many of the families voicing complaints about TI are not objecting to the structure of the intervention itself. They are reacting to the outcome of their case. Often these parents who disagree with the court's findings, or who may be struggling with being held accountable to behaviors that contribute to their current family functioning. These are dynamics where parents may be polarized in their positions or have weaponized a tool that is meant to be helpful. It is also important to recognize that TI is not applied to the average family court case. This is not a service most families will ever experience. These complaints are coming from a small percent of family court cases, the most high conflict, entrenched, and often clinically complicated situations. And more often than not, these are cases where there are underlying mental health diagnoses in a parent or child that exacerbate the difficulties in the therapeutic process. TI is typically court-ordered after litigation has occurred, after evaluations, after hearings, and after the best interest findings have occurred. This process does not happen in a vacuum. This is often a last effort to help families, and when done properly, TI is designed to restore safety, repair relational damage, and interrupt harmful dynamics that keep children in the middle of adult conflict. At its core, TI is grounded in family system therapy. In fact, it's fundamentally the same clinical process as traditional family therapy, focusing on helping members of a family system rebuild trust, improve communication, and function more safely together. The primary difference is that TI is applied in a court-involved context where compliance and structure are often essential to progress. TI is also not unlike the services presented in Arizona's own DCS. They use family preservation and reunification cases. DCS frequently uses structured therapeutic models to address parent-child resistance, support parenting skills, and introduce safe contact. TI follows the same evidence-based framework. It simply serves families navigating family court, not child welfare court. TI is not about reunifying a parent and child. It's about giving families a new belief system, one built around boundaries, emotional regulation, and healthier communication. It's often requiring both parents to shift their behaviors and take ownership of the part in the conflict. I understand the concern about cost, but TI is often far less expensive than the alternatives. Custody evaluations in Arizona can cost tens of thousands of dollars. Prolonged litigation over parenting time can cost even more. A TI is a structured, child-centered way to reduce conflict, not increase it. On a personal note, my own family is currently navigating the challenges of a high conflict dynamic. We have been in litigation for 10 years. Like many parents in this situation, I have a child who is struggling with the impact of years of litigation and division. Without access to structure, neutral support like TI, I worry that the damage will deepen, not just to relationships, but my child's sense of stability and safety. TI would provide a healthy path forward. Without it, families like mine are left with nothing but litigation, and courtrooms are not where children heal. My concern is that without TI, families stuck in high conflict, especially those who have already failed
1 minute.
in traditional therapy, will have no structure path forward. And if TI disappears without a viable alternative, those children and families will be left with even fewer tools for resolution or healing. Families in conflict don't need fewer resources. We need resources that are ethical, accessible, and effective. When TI is done well, it has the potential to be exactly that. Thank you for your time and your thoughtful consideration.
Thank you, ma'am. I got a whole bunch of questions for you.
I have.
So you said something about not in a vacuum.
Yes.
How often does the court talk to a child? I'm sorry, I'm not gonna say child. How often does the court talk to a minor who is involved?
The court directly or appointees?
The court directly. Seems like mom and dad both get to have their word in court. What about the kid?
It's rare.
I'm not so sure that I believe this, because so far, the testimony we've heard, while there may be conflict in the background, 14 years, $550,000, and then the problem gets solved in 3 weeks with $2,500? That, ma'am, points to competency for me. How much do you know about the origins of, I presume since you're a licensed professional, the origins of this notion of parental alienation, that where this whole echo chamber came from?
Are you asking me to speak to the statute, or are you asking me to speak on it?
In your profession, in your training, I presume that you've got some kind of basis for this parental alienation theory that has been presented?
Well, parental alienation falls under child abuse, which is a DSM. That is a DSM standard that is used. And the word parental alienation is a buzzword, but at its core, psychological abuse, emotional abuse, those are all defined within the DSM.
I'm glad you used the term buzzword, because I think that's what it probably is, quite frankly. Would you say that when a parent remains silent about the co-parent's behavior, that that's a form of alienation?
I think if parents are wanting what's best for their children, they should be solution focused and trying to to resolve the issues at hand. I personally am being affected by that. I know having a silent co-parent is not helpful to resolving issues.
Okay. Well, we do have this thing called the First Amendment.
But
You can
to what
choose to say something or choose not to say something.
Certainly, but when it's to the detriment of our children, we should be working collectively and collaboratively.
Okay. Well, let me ask you this question, and I've heard this from a number of people in the room. When you have a parent who is engaged in behaviors that the co-parent finds objectionable, they're kind of, it seems like they're caught in a catch-22. If they say something about the parent's behavior, they're alienating the child against the parent who's engaged in the behavior. If they say nothing, then they're alienating the child because they said nothing.
So this is where the framework of working with a mental health provider to work on their co-parenting skills and you have to redefine the new family system. This child is put in a position oftentimes where they have to pick the love of one parent over another. And that's simply not a true belief. The children or a child can love both parents equally just because mom doesn't like dad or dad doesn't like mom. We have to create a new system and a new belief. That's really what a TI is supposed to be doing, is help reframe this new family system.
Mr. Chair?
Do you think it's the court's job to fix people?
I don't think it's anyone's job to fix people other than the person themselves.
Right on point. Thank you. Members, any questions?
Mr. Chair?
Ms. Fink?
You mentioned a couple different times that you are in charge of helping develop new belief systems or redefine the family. Do you believe that's the role of the TI or the courts?
Well, again, I'm not here in a professional capacity. I'm here as a parent. I just happen to have this experience.
Okay.
Mr.
All
Chair.
right, ladies and gentlemen, I'm not going to say it again. Please show Ms. Alcott some respect.
Okay.
Ms. Fink?
Yeah. Oh.
Were you done?
Yeah, I'll go ahead. Yeah.
Mr. Chair, so I have a question, Ms. Alcott. The courts, when they order a TI for a family for the reunification, do they have to have a hearing to figure out what the interests of the child are at that point? How is there a process, I guess, before they just appoint a TI to a particular case?
Certainly. So there's usually ongoing litigation. So there are multiple hearings held, multiple issues raised, and the parties aren't able to get out of that situation. They are polarized in their positions. So after hearings or even trials, the court finds it's in the children's best interest for the parties to explore therapeutic processes, which can be court-ordered, cannot be court-ordered. It very much depends upon the judge.
Well, Mr. Chair, a follow-up, don't you think it would make more sense to streamline it into being the same for each case and not just, oh, it depends on what the judge feels like that day?
It's difficult because every case is unique. While the themes may be similar in nature to what many of us are here for today, each case is unique and individual. Each case has its own set of caveats and presenting issues. Each case has its own set of allegations. So it's not as simple as it is just to streamline everything. Collectively, we should be working as a group of parents, as a group of providers, and with our legislator and our judiciary to come up with collaborative solutions that work best.
Okay, Mr. Chair, Ms. Alcott, to follow up, you understand there is Arizona statute that requires specific things for a judge to look at when it's best interest of the child. Mm-hmm. And when there's abuse, allegations of abuse and things like that, why are certain judges continuing to give the abusive parent? So are you telling me the judges get to decide from the bench what they feel like that day, but they're allowed to just break the state law?
No, not at all. What I'm saying is that in some cases where abuse is alleged, they have run through those state statutes, they have weighed the evidence. Oftentimes there are multiple providers involved, including police, DCS, and none of these are substantiated. And this creates the difficulty in these high complex family dynamics. Just because a parent says that the abuse happened doesn't make it factually true. There are investigations that go into place to determine if that actually occurred and to what degree and level, and the court gives it the weight that it deserves according to the statute, and if they make those findings on a case-by-case basis, then that is how the court rules.
Okay. Mr. Chair, just one more about the reunification process itself. Can you give me solid data and evidence that that actually works, the reunification process, which, by the way, SB 1372, that's not supposed to be happening anymore, but I hear it is. But do you have actual data to back that up, that the families that have a TI in their case have been put through these reunification camps, that it actually is helpful in having a good outcome for these families and these children specifically?
Offhand, I know that there is research to support family system therapy, and I'd be more than happy to provide you all with that data. In terms of TI specifically, I was just speaking today with another individual that I want to, in fact, pilot a study to tease out these issues, to see what the success rate is. What is it like with one provider versus another provider? What modalities are they using? I think that information would be very helpful to helping resolve some of these families' complaints, and then also help the legislator and the family court be able to navigate what processes would be appropriate moving forward.
Senator Warner.
Thank you, Mr. Chair. Ms. Alcott, how many cases does a typical TI have?
It varies. It's very much on a case-by-case basis. Some TIs do take on TI work. I know other providers that do not. I know more TIs are going away from TI work just because of the implications of board complaints, and they don't feel that it's necessarily maybe the most helpful or beneficial, or the case is too complex, or there are other issues at hand. I can't give you a specific number to that.
Okay, thank you, Mr. Chair. Follow up.
Please.
Who employs the TIs? Are you guys paid by the state or individual service providers?
So it is through a court order, and typically a TI will get an appointment, and in that court order is the appointment sheet, and it's about anywhere from a page to 8 pages long, and it will assess the fee structure of what the parties are to pay. So think of it as court-ordered private family therapy.
Just to follow up, do you work for an agency or for the state?
I work independently, so I do not work, while I do have a contract with the state and juvenile court to provide parent social worker services, I do not work directly with the state.
So, Mr. Chair, would it be accurate that the TIs mostly work independently?
Yes.
Okay. And do you work at like fee for service?
So myself in particular, I can only speak for myself. Okay. And again, I'm not here as a provider, I'm here as a parent. I do offer a sliding scale. If the court makes a finding that a party is, indigent, I do reduce my rates. I am currently finishing my master's, so I am not doing TI work personally. I run a supervision agency, but I do Rule 81 work, which is case implementation supervision. So I am there just to oversee that court orders are being followed. I don't make recommendations. I simply notify that these things are happening or not happening. I know some TIs do offer sliding scale. Some do not. I know that there was recently a document that was started where parties that needed certain evaluations were being done on a pro bono basis, but it's still at its pilot phase. So the providers are trying. We do understand the parties' concerns. We do understand the legislators' concerns about cost. I echo in that cost can be problematic.
Last question, what is the typical fee for a TI hourly?
TI costs vary anywhere from $150 to $400 an hour.
Thank you. Appreciate it.
I have a question,
Members.
Chair. I have a question.
Senator Totley.
Thank you, Chair. Thank you very much for your testimony. My question revolves around a certification of a TI. Do they provide? Is there a TI certification or process, or how does that position become licensed?
So, and this is where it gets complicated, and where often many parents then turn to other measures. So in the court appointment order sheet that I mentioned earlier, it will list what, if they have any credentials. Oftentimes, these are licensed providers that hold either a behavioral health license or a psychology license. Those are the providers that are typically appointed to do TI work because it is, again, therapy that we are supposed to be focusing on and doing. Whether or not they have that, that would be up to the boards, the respective boards, to oversee and handle any of those complaints.
Follow up.
Please proceed.
And these licenses are provided by the behavioral health boards, right?
Correct, and the psychology boards.
Okay, so one more question.
And to that point, which one?
It depends. So if they are a master's level provider, they will be licensed and either have a license or not under the Behavioral Health Board, or if they have a PhD or PsyD, then they will be licensed with the Psychology Board. So you can have a PhD level provider or a master's level degree provider. So think licensed clinical social worker or a licensed counselor versus that of a PhD or a doctor.
Okay. Senator Totley.
Now I have some more questions. Thank you.
It's like an onion, isn't it?
Yeah.
Yeah.
So, thank you for that clarification. It opened a whole new window of questions. So if there's a license as a master's or even as a PhD, does that sliding scale change?
It depends upon the provider's rate of what they set their services to. So for example, I would assume that a PhD level provider is probably a few $100s an hour, whereas a master's degree level provider is maybe more in the $100 to $200 an hour. It really depends upon that provider and what they choose to set their rates to.
Chair?
Please.
So then I think in practice, extracting that data would be beneficial just as an audit purpose. And then the other thing too, one more question is, what is the history of a TI?
Can you clarify what you mean?
So when did the court start bringing TIs? Has it always been? I was going through a divorce years ago, and I've never even heard of a TI back then. So is that new in the court practice?
I would say it's relatively new in terms of statutory, and legislative means. I think that it's also very much by county. I know there's several counties in Arizona that don't really offer TI or have very limited resources for providers for TI. I know personally that TI has been around for 13, 14 years. It could be longer than that. The names sometimes change. So TI, COBE, therapeutic interventionist, there's just a lot of different names sometimes that get interchanged over time.
One more question?
Yeah, please.
One question that's really two, but first of all, what does COBE stand for? What does it do? And then also, is there ever a time when an individual, like let's say somebody who may have had some community college work would possibly be appointed as a TI by the court?
So let me answer your first question. So a TI and a COBE are in essence the same thing. A COBE is a court-ordered behavioral interventionist. See how the words are similar but interchangeable. A function of a COBE is to also help the family system. Oftentimes, the court has found that both parents are fit and proper, whereas with the TI, we have safety concerns. And a COBE typically is done when parties agree to utilize the services. TI is usually in the form of a court order. Both typically end up resulting in court orders being issued for provider clarity and scope being clearly documented and outlined. In terms of education, certainly, I mean, a provider that goes to community college and goes all the way through and gets their master's degree or a PhD, that would be appropriate. You don't have to be from Harvard or go to an Ivy League school to be a provider. That's up to the licensing board to oversee what those credentials are and if it's appropriate and meets the Arizona statutes of what would be a required licensed provider.
One last question. Or point of clarification. I'm sorry. Well, she brought up something. She brought up something. I have to do a point of clarification. And the reason why I asked this question is because sometimes things happen where individuals are provided something, even though it's outside of statute or requirements. That's why, and I recognize you can go to a community college and become have a PhD. But my question was just a point of clarification that if there's ever a situation that a court can appoint an individual without higher education or even a credentialing as a TI, is a court able to do that? Or have they done that? I'm just asking for clarification.
I mean, in essence, a judge can order whatever they would like, and that's why we have the Court of Appeals, which it's the unfortunate truth. It doesn't happen too often, to my knowledge. Oftentimes, it's an agreement of the parties. So, for example, if the parties agree, they have to agree now to parent coordinating. They agree to who that individual is, and that then is written in a court order. Oftentimes, though, the court is aware of who providers are, and that is who they often implement. Or if there's a different name and the parties agree, the court oftentimes agrees with the parties' agreements, and they sign off on that.
Thank you.
I take great umbrage that the court can do whatever it pleases. The court has to act within the confines of the four corners of the law. And we are about 8 minutes out of being out of time. Representative Keschel, please.
Yes, Mr. Chair, I just have one point of clarification. Just because you shared a lot of expertise with us today, are you a licensed TI? I know you're here on a personal level, but just for...
No, I do not provide TI services.
Okay.
I am currently finishing my master's, so I work under a provider who provides TI services. And based upon our current licensing board, I can provide reduced rate TI services under their license with their oversight. But I personally do not do that work.
Okay, members, any other questions? Unfortunately, ladies and gentlemen, we do not have sufficient time to give another speaker 5 minutes, but I am going to make a couple of closing comments. I am very concerned, after what we've heard so far, that the civil rights of children and parents have been violated, not just by the court, but by quasi-officers of the court. We are going to have 4 more hearings. Members are probably going to want to commit mutiny, but I think the next one is going to be more like 6 hours as opposed to 2 hours. It's very clear that 2 hours is not sufficient time. And you have my profound apology for that. I knew that this was going to be well attended, but I did not know that we would have over 30 speakers. In fact, that number seems to be growing. If you would, there is a JOT form that we are collecting data on. And I'm not going to ask you to remember the email address, but if you write me an email requesting the JOT form link, I'll see to it that that is sent to you. It's M. Fincham, that's F like Frank, I-N like Nancy, CHEM, like Mark, at azledge.gov, or you can just go to azledge.gov, click on the member roster and find me. We will see to it that you get that information. Thank you, everybody, for coming today. I urge you to do a little bit of networking. There are some folks in this room that I think are prepared to help you. I sense that this is a fairly well-networked group already, but I will be here, and I'm sure the other members of the panel will be here after we adjourn. Representative Keschel, would you like to make a closing comment?
Yes, thank you, Mr. Chair. It's hard not to get emotional with this. You know, that you try when you're a legislator to kind of separate yourself from some of that. That's been really difficult. In this situation, a family was brought to me way back in August, and I have met dozens of you since. And I just want you to know, and then when I found a wonderful ally in the Senate, in Senator Fincham, that we are both, our hearts are in this for you. We hear you already, we really do. We know that there are issues that need to be addressed. And I think one of the most profound things that was just said in this hearing is that judges do what they want. And that's a problem. There's something called checks and balances. And that's why your legislature is here now, to put some checks and balances on a very flawed system. I'm honored to be working with these people here. I know Representative Fink, she's known a lot of you for even longer than me. And I look forward to what we can achieve through this. Thank you.
There's a piece of legislation that will be coming before the Senate, perhaps later this week. Do we know what 2256 is looking like? Okay, it's in the process, okay. House Bill 2256 is being amended and will address part of the problem. And I want to lay out the concept of incrementalism. This is in my view, what I've heard so far tells me that there's a big problem here. You don't take big problems and solve them with simple answers. That is a recipe for disaster. But if we can get ourselves to the place in statute where we go back to that which is permitted and that which is prohibited, that is a step in the right direction in my view. But we'll need to have the involvement of, this is probably one of the largest focus groups I think I've seen in a long time. I know that I can speak safely for Representative Keschel, probably every member of this panel. We need to have your engagement if we are going to improve the system. It's not going to happen overnight, but it will most assuredly happen. With that, this committee is adjourned.